Hi, my name's Lorena Sadie. I am the founder and managing attorney here at Sadie Law Group, where I practice. I've been practicing bankruptcy law now for about 24 years. Yes, I'm an old lady in bankruptcy, but I wanted to do this video about how not to screw up your bankruptcy hearing, because I am seeing some crazy things these days. Thank goodness, not from my clients, because I prep my clients before hearing, and I tell them, this is the way the hearing needs to work. But apparently that doesn't always happen. And I am seeing some stuff and you're just shaking your head saying, what are you doing? So this just is my little tip on how not to screw up your bankruptcy case. So first thing, how not to screw up your bankruptcy case is to be honest. Be honest and make sure all of your creditors and all of your assets are listed on your bankruptcy attorney or bankruptcy petition. Sorry. You give it to your bankruptcy attorney, but it better be on your petition. Make sure it's listed. You are reviewing this document. You are signing the document saying it is true and correct under penalty of perjury, not your attorney. I mean, if you lie or you don't disclose things, your attorney's not getting in trouble. You're going to get in trouble. So you need to make sure that you review those documents. Very, very important. So that's the first way not to screw up your case. Now, second way not to screw up your case. Make sure that you're on time for your hearing. I mean, at least where I'm at in Georgia, we're doing all of our hearings by Zoom. So give me a break. You can't find 15, 20 minutes to go sit in your car and get on a Zoom call? I mean, these days, seriously, you can say you gotta take a long bathroom break at work if you really need to, but you are gonna have a heads up a month before your hearing telling you when your hearing is, what time. For us, it's just what is the Zoom code and passwords you put in. I mean, give me a break. So you need to make sure that you are on time for your hearing. If you're not on time, usually the trustees are nice and they'll reschedule it once. You miss it again, your case is dismissed and you get to start all over again. And you get to pay attorney fees all over again. So why on earth do you want to screw up your case just because you're not being responsible with calendaring a hearing? There's just no excuse. And by the way, you also you're going to get a notice of this hearing in the mail, physically from the court. So they're not going to, oh, I didn't know. Yes, you did. They mailed it to you. Now, if you're one of our clients, we're also going to email it to you. We're going to be sending you little reminders. Hey, don't forget, don't forget, don't forget. So second way to not screw up your hearing, make sure you're there on time. Now, let's talk about behavior during the hearing, because I have seen some just really atrocious behavior these days. And I'm just sitting there thinking, you are shooting yourself in the foot. You are literally killing your case. You are inviting the United States trustee to open an investigation into you. And I don't know if their attorney didn't tell them or if they just don't listen. But the third way you can really screw up your case is to get nasty and hostile with your trustee. So you're the one that has said, I'm having problems, I'm having debt issues, and I need to go to the courts for protection for my creditors. You are the one making that choice. Nobody is making you file bankruptcy. You are making that choice. So with that choice comes responsibilities. And one of those is you have to attend your hearing and you have to answer some questions about your assets and your income. And again, the trustee, they are just doing their job. And yes, I know some trustees are better than others. Yes, I get it. Some have nicer demeanors. We're lucky here in the Northern District of Georgia. We have great trustees. We really do. But you may live somewhere else and you may have some jerk that's your trustee. But you know what? They're allowed to ask you questions about what is in your petition, and you have to answer them. So you'll see people and they start fighting with their trustee. That is the most idiotic thing you can do. Number one, you look guilty and that you're hiding something, which maybe they are. And then you're just pissing the trustee off. And, I've seen trustees say, you know what? I got other cases to do. I'm going to reschedule your case. And then what they'll do is if you still have this kind of behavior, they'll make a referral to the United States trustee, which is the little office or big office, I should say, that governs all of our hearings and makes sure everybody's doing what they're supposed to. I mean, you are going to be just entangled in in discovery requests, additional hearings, probably depositions, all because you're acting like a jerk on the hearing. But don't do that. I mean, I would think common sense would tell one, you want to be polite. Yes, sir. No, sir. Yes, ma'am. No, ma'am. You do not want to be fighting with your trustee. If they ask you a question, you need to answer it, and don't be cute. Don't try to be like, well, I don't feel comfortable. Da 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 da. They're asking you about your debts and your assets. So if you're hiding something, that is a problem. But you do not need to be nasty or have attitude with your trustee. Okay, so just keep that in mind. They are well within their bounds to ask you about your living situation, about who's living with you, how much money they're contributing. So they can ask you all those questions, most certainly. So just make sure that if you decide to get into a bankruptcy, that you understand that you got to check that attitude. I mean, you're going to the courts asking them to help you. So you can't turn up at your hearing and be a snot. That's just dumb. Just dumb. So don't do it. Do not do it. And again, I would think that your attorney would make sure you understand that, but from what I've seen in court, sometimes that does not happen. So don't do it. The fourth thing I would suggest to folks in terms of how not to screw up your hearing is to make sure when you are doing your hearing that you are, for us, like we do ours by Zoom, they tell you at the beginning of your hearing, you need to be by yourself. You need to be in a quiet place. So you need to make sure that you are in a quiet place, that you are by yourself, because that's what the trustee is requesting, and you need to abide by that. You also need to make sure that you can see, that your Zoom is working. You can see everybody. They can see you, because you may log on to your hearing, at least for those of us who do it by Zoom, and then there's a technical problem or whatnot. So you need to make sure that you've got all of these things taken care of beforehand, because the trustee is going to get frustrated because they have a calendar. They have so many hearings they have to do. They don't have time for like that kind of nonsense. They're like, okay, well, you didn't figure it out, so just going to reschedule you. And then if you don't figure it out again, we're going to dismiss the case, and you'll need to, get with your attorney or go to your attorney's office so you guys can figure it out. So, you got to make sure that, you do that as well. Now, let's talk about the last way not to screw up. Don't screw up your bankruptcy hearing. And that is if you have a creditor that shows up. Now, most of the time, creditors do not show up on 341 hearings, unless you have like an angry ex-spouse that wants to get you. That could happen. That's always interesting. That's time to pull out the popcorn when that happens. But for most people, for the average case, your creditors aren't going to show. But sometimes they might. Sometimes you might have a car, or you might have financed like an HVAC system or something like that. So you might have a creditor, show up. So if that happens, same advice as when the trustee is asking you questions. Now, the creditor is allowed to ask you questions. However, they can only ask you questions that pertain to your bankruptcy petition. So they can't ask you like insulting questions. Have you always been a scumball, not paying your creditors? Were you lying to, so there is a scope. And if you have a good attorney, your attorney should be the one jumping in and ensuring that only proper questions are happening. Sometimes I'll see folks doing a hearing and they have an attorney, and some creditor is asking way inappropriate questions, and it's just going off the rails, and the attorney's just sitting there not saying anything. And it's like, hey, you need to jump in and protect your client. Now, again, this is the meeting of creditors, so you do need to answer the questions. Does the collateral have insurance? How long have you been at that job? Has the vehicle been wrecked? I mean, these are all valid questions. But again, the credit, this is not where they get to insult you and say nasty things to you, or bring up your personal life that would have no bearing whatsoever on your debts and your assets. So there is a line. So you need to make sure that your attorney is there you have a good attorney there that's going to make sure that line is maintained. I will say where I practice, most of the creditors are great. We all know each other. We have a very professional decorum when we're doing these hearings. I mean, we're doing this every day with the same people, but every once in a while you'll see some attorney that comes in, and they are, or just not even an attorney, because you don't have to be an attorney to show up. You'll see sometimes creditors are just angry. You know, I just mentioned ex-spouses, and you'll just see really inappropriate things getting thrown out that really that's not the place. So, you know, the last way to make sure that your hearing goes well is if a creditor comes and they're asking you, of course, appropriate questions, you do need to respond to those. Don't get nasty. Don't get emotional. That's the fastest way to, you know, to take your case off the rails. And what happens is when things go bad in your bankruptcy hearing, now the whole process is going to get expanded. Now you're looking at it's getting rescheduled. There's a deposition. The United States Attorney's Office gets involved. You're getting charged more legal fees because now your case isn't some simple Chapter 7, you know, or 13 case. Now your case is like a lot of drama and it's a lot of legal work. And, you know, we're lawyers. We don't work for free. So if you cause more work, you get charged more money. Kind of common sense. I always tell folks that, you know, they, you know, if something crazy happens in their case and they have to, you know, pay more fees, I always say, well, do you work for free? I don't work for free. And most attorneys are going to spell out for you, you know, your bankruptcy, the fees that you're paying are covering this. Of course, if you add, you're going to get charged. So save yourself time, money, and a headache, and just make sure that you are behaving properly, you're on time, attending your hearing, and that your documents are correct. Then your hearing's a breeze. It's smooth, it's easy, no problem. You do your hearing, you wait your 90 days, you get your discharge, life is good. And you know, most people that's the case, but you know, like I said, lately I've just been seeing some crazy things when I'm doing hearings, and I'm just, you know, did no one tell these, you know, people? I don't know. But anyway, that was the purpose of the video. If you have any questions about bankruptcy, you are always welcome to shoot me an email. My information is in the description below. Thanks so much.